Good morning. My name is David Traskey. I'm a partner with Garfunkel Wild's Investigations, Audits, and Regulatory Compliance Practice Group. I recently joined GW after many years of service with the U.S. Department of Health and Human Services Office of the Inspector General in Washington, D.C. And so, as part of those roles for the OIG, I spent time investigating False Claims Act cases, litigating and settling um, cases under OIG's civil monetary penalties law authorities, litigating provider exclusion appeals, and processing self-disclosures and providing general compliance and other compliance monitoring guidance to the provider community. Um, with that background, it's my pleasure to be with you today to talk a little bit about OIG's what OIG is focusing on in the ambulatory surgery center space. Here's our agenda today. Not too bad. We're going to talk a little bit about OIG's new frequently asked questions process. We'll do a quick refresher on relevant laws. Talk about how the new frequently asked questions process applies to ASCs. And then time permitting, we'll talk a little bit about some recent OIG and DOJ settlements that occurred in the ASC space. So for those of you who may have been on OIG's public-facing website and seen their frequently asked questions page, you'll know that the information there is pretty generic, pretty bland, and generally it's more advisory in nature, talking about procedural in nature, in the sense that it talks about procedural issues stemming from or coming from advisory opinion requests and things like that. And historically, that they didn't provide a whole lot of guidance to the provider community. But during the pandemic, OIG began to use its FAQ page in a new and different way. And part of the reason that they wanted to do that is because they wanted the provider community to have an appreciation and understanding for how OIG's administrative sanctions would apply to the providers, particularly during the pandemic, and to be able to give providers some additional insight and flexibility so that they could really focus on what was the most important, and that was caring for patients. And so during that process, or during the pandemic, the OIG began to also, in the background, solicit feedback from relevant stakeholders, providers, entities, and others about how they used OIG's publicly available documents, whether they were related to the audit and investigation reports, the formal advisory opinion process, matters related to the list of excluded persons, and so on. And one of the things that they wanted to do as a result of this process was to get a sense of not only how the provider community used those items, but figure out a way in which they could make those items more useful, more timely, and more accessible to the provider community. And in the course of that process, they did some surveys and things like that. And one of the things that came out was that the provider community generally thought that the formal advisory opinion process was slow, it was cumbersome, it was not very efficient or quick. And so OIG began to think about different ways in which they could balance the competing interests that providers had, not only to get sort of a very thorough explanation that you would normally see in an advisory opinion. Those usually have a pretty substantial discussion of the facts and then an application of the law. Trying to figure out how to kind of manage that need with the sort of the other need of the providers that was articulated, which was to have a kind of a more expeditious and quicker way to get information, particularly in the face of a rapidly changing healthcare environment. And so the end result of that was that in March of this year, OIG unveiled a new process for using their frequently asked questions page. Right. So now, for the first time, providers can submit questions electronically to OIG's FAQ page, and they can submit on a variety of topics, and primarily on topics that were previously reserved for the formal advisory opinion process. And as I mentioned a moment ago, they're trying to balance these sort of competing interests with an eye towards promoting economy, efficiency, and effectiveness and integrity in federal healthcare programs and the beneficiaries that get served by it. And so, like anything else, you have this new process, but there are some caveats. Here are 4 big ones listed here on the slide, right? So the new process, although it should be more expeditious, I guess the answers to the FAQ questions that are set forth, understand that they're informal and non-binding guidance, and it won't provide prospective immunity from administrative sanctions, and they will not provide opinions about potential liability under the False Claims Act or other criminal matters, criminal law or other legal authorities, particularly relating to billing, claim submission, cost reporting, or related conduct. And importantly, like I said, not only is it's non-binding on HHS, but it's also non-binding on the OIG and the Justice Department and any other entity that may be floating around out there who has an interest in these types of answers. And then the last one, of course, subject to FOIA. OIG has said that they would do their best to, maintain the privacy of the individuals submitting questions as far as their responses go that are posted, but they may not be able to have that same luxury, in the event of a FOIA request. So in addition to these big 4, there's a couple other ones that I think are worth noting. In addition, OIG has said that they're not going to be obligated to answer every question that comes in, and they may tweak the questions that they do get to sort of make them questions of general applicability. And if they do publish a response, they may, but they're not obligated to notify the party that submitted the question. And so, on its face, it looks like this may be a good way to get some more answers expeditiously from the government. But I think, like anything else, the sort of the devil is in the details. And so we have to take this with a grain of salt, especially given these caveats and given the fact that it's a relatively new program. It sort of remains to be seen just exactly how well this new process will work. All right. So now we're going to move to just a short refresher on the kickback statute. As you can see here from my friend Warden Norton, if anybody out there is a fan of the Shawshank Redemption, you'll recognize him. But under the Anti-Kickback Statute, paying for referrals is a crime, right? And the kickback statute is a criminal law that prohibits the knowing and willful payment of remuneration to induce or reward patient referrals or the generation of business involving any item or service payable by the federal healthcare programs, right? And the interesting or the important thing to remember here is that it's not that remuneration can be anything of value. So, while it may be, cash in a paper bag, or in the case of Warden Norton here, cash under the pie plate, it doesn't have to be that. Remuneration can also be things like free rent, expensive hotel stays and meals, excessive compensation for essentially sham consulting agreements or medical directorships. But either way, paying for referrals is a crime. And surprisingly, I think that the other important thing to notice is who it applies to, right? So it casts a pretty wide net in terms of applying to those who both offer and pay the kickbacks, people who solicit and receive those kickbacks, And it applies to all patient referrals, including patients. And you may say to me, well, Dave, how can it apply to patients? What are we talking about? And so let me just give a quick example here. And I think this is one that you may all be familiar with. So under Medicare and Medicaid, there are requirements that patients pay copays for services, and providers are generally required to collect that copayment as part of the service. And one of the issues that arises, of course, is that, and gives rise to liability under the kickback statute, is the routine waiving of copayments. So generally speaking, there cannot be a routine waiver of copayments, otherwise it gives rise to potential liability under the kickback statute. And of course, there are certain circumstances in which you can waive that copay. Certainly if you can't advertise the fact that you're going to do it, but it can be waived in certain circumstances, like for instance, if you make an individual determination that a particular beneficiary is not able to pay the copay, or if you've made reasonable efforts to collect the copayment and those efforts have failed, right? So that's an example where it would maybe be okay to do the waiver, but you can't do blanket waivers, otherwise it implicates the kickback statute. So the safe harbors under the kickback statute, they're meant to describe a scenario that would give rise to potential kickback liability, but for a variety of reasons, those activities are not treated as an offense under the statute. And what's relevant about the kickback safe harbors is that compliance with the safe harbors is entirely voluntary. You get no protection under the safe harbor if you only partially comply with the conditions of the safe harbor. And but that being said, the failure to comply with the safe harbor doesn't mean that the arrangement is per se illegal, but it is certainly one that you should look at carefully and understand all of the risks associated with it. So back to the frequently asked questions process that we were talking about at the top of the presentation. OIG's frequently asked questions, the new ones, they recently put out a question related to ambulatory surgery centers, and in particular, it relates to investment interest in a single specialty ASC. And so, there are a few different safe harbors for ASCs, depending on, how they're owned and operated and things of that nature. But in each instance, regardless of which safe harbor you're trying to satisfy, there is what's called the practice income test. And that's that at least 1/3 of a physician investor's medical practice income from all sources for the previous fiscal year or the previous 12 months be derived from the performance of quote unquote procedures. And procedures in this context means the procedures that are outlined in regulation that for which an ambulatory surgery center can bill. So regardless of whether it's a surgeon-owned ASC, a single specialty ASC, a hospital physician ASC where you've got the hospital as one of the owners, or multi-specialty ASC, that practice income test applies to all of the different types of ASCs, and that's just but one of the many conditions that are required to get the protection of the safe harbor. So the question that's posed here in the ASC from the ASC FAQ, as you can see, is, if all of the other elements are satisfied, right? So we're assuming that all of the other elements are there and have been satisfied. Can an ASC offer an investment interest in a single specialty ASC to a physician who derives less than 1/3 of his or her medical practice income over the course of a fiscal year or the previous 12 months from the performance of procedures, right? OIG's position is that remuneration to a physician in the form of an investment interest implicates the ASC, particularly where the physician investor is making referrals to the ASC. You may say to yourself, this is great information, but why should I care, right? And I think that the big, the big the why you should care is that it's reflected there in the first bullet point, right? The failure to satisfy the safe harbor under the ASC's practice income test means that the income that's either received or distributed as a result of the investment interest is not protected under the safe harbor. And why is that, right? It's because that OIG's position would be that physicians who satisfy this practice income test are more likely to use the ASC as an extension of their own practice rather than, kind of a way to induce or reward referrals for procedures that they're not personally performing. And if you remember, one of the things that OIG looks at when they're assessing potential liability under the kickback statute is they're evaluating risk on a spectrum. And so, if you meet all of the other criteria except for this practice income test, one of the things that they're going to do then is to sort of look at the totality of the circumstances, right? And they're going to be looking at some different things in terms of, for example, whether a physician intends to refer patients to the ASC for procedures that they'll personally perform, whether they're going to refer patients there for procedures that they're not going to personally perform. And then they're also going to look at what are the circumstances that are causing the physician investor not to be able to satisfy that the income test. And the reason why they're so interested in these types of arrangements is because, from their perspective, if you are complying with the safe harbor, then that reduces the likelihood of overutilization, the corruption of medical decision making, patient steering, or unfair competition. So before we head into a discussion of some recent settlements, I just want to recap for you for a moment, right? Which is, so the benefits of this new FAQ process is that it allows providers and other stakeholders to get answers to their questions more rapidly than they would otherwise be able to get through their informal or through the formal advisory opinion process. This is, I think, in my mind, particularly useful to an ever-changing healthcare landscape. So I think that's really the big benefit of it. It just gives providers and entities another avenue by which to reach out to OIG and get some good feedback. Of course, the limitations are numerous, as we discussed. Remember those caveats there, and of which there are many. And I think that it remains to be seen kind of the value of the FAQ. I'm hopeful, but we'll have to wait and see kind of what it looks like as it develops. And I think the other two sort of caveats that I would leave is that to be mindful of, the manner in which one would potentially use that new FAQ process, right? Certainly, we would want to think carefully about whether or not it makes sense to use it for a super complex fraud and abuse question. Probably not. And the other thing that was noteworthy about the limitations is that unlike the formal advisory opinion process, in which you can sort of pull back or withdraw your opinion if the OIG sort of gives you the heads up that the opinion is going to be potentially unfavorable, there is that withdrawal mechanism in the formal advisory opinion process, and that's not available here under the new FAQs. And so there's just, again, pros and cons to considering the use of the FAQ, but the fact that it's out there, I think, is a nod in the right direction. And so, the risks, of course, to violating the kickback statute are numerous, right? There's criminal penalties, there's administrative sanctions, including fines, jail terms, and exclusion from federal healthcare programs. There's also, companion liability under the civil monetary penalties law for physicians who pay or accept kickbacks. and those physicians face penalties of up to $50,000 per kickback and 3 times the amount of the remuneration, whatever that is. And then, of course, also there's the risk of being excluded from participating in federal healthcare programs. So from this, what we can gather obviously is that it's important to stay on the right side of the kickback statute. Otherwise, the risks are great. And in addition to that, I think the other thing that I would share with you is that OIG's, looking at the provider community sort of as this bell curve, right? And if you picture a bell curve, sort of the biggest part of the curve probably makes up like 80%, right? That slice in the middle, and then you've got the tails at both ends. OIG, I think their perspective generally is that the vast majority of providers are trying to do the right thing, right? And so that's why you've got that's the folks that fall into the biggest part of the bell curve. On the front end of that curve, you've got sort of the compliance superstars who are doing great, but it's on that back end who maybe are of providers who are not doing so great. And so that's why the federal government has implemented several fraud and abuse laws, and states have sort of adopted similar companion rules to it. And from the OIG's perspective, one of the other things that they're trying to cultivate amongst the providers who participate in the federal healthcare programs, namely Medicare and Medicaid, is trust, right? So they want, and as it should be, trust is oftentimes the foundation of a really good doctor-patient relationship, and OIG wants to ensure that that relationship is not damaged or corrupted by the payment of kickbacks or other sorts of inducements. I often tell providers when they talk about participating in these programs that they need to understand that the relationship that they have as a participant in Medicare and Medicaid is oftentimes like a 3-way relationship. And I don't mean the type that you might hear about in a tabloid, but you've got the patient and you've got the doctor, and then obviously you've got the federal government, right? And they are just like any other relationship, right? Each party comes to it with their own expectations. But I think as a whole, the government would say that they are not, and OIG would say that they are not interested in interfering with that doctor-patient relationship. They're just making sure that it's built on a good foundation. All right, so in our remaining time, we're going to talk a little bit about some recent settlements that involve ambulatory surgery centers and what we might be able to learn from some of these lessons. So as you can see here up on the slide, in April of this year, Northern District of Georgia, an FCA case where 2 physicians and a company that they created, along with 18 other anesthesia entities that the company owned and operated, agreed to pay over $7 million to resolve allegations that they entered into kickback arrangements with referring physicians in exchange for the referral of the physician patients for anesthesia services. As many of you know, anesthesia providers typically depend on hospitals and outpatient surgery centers for their income. And if a provider can secure an exclusive contract for anesthesia services at a center, it guarantees steady income, right? And so as a result, anesthesia providers are aggressively competing for these types of contracts. And essentially what the government alleged was that between 2012 and 2016, so over a 4-year period, these 2 physicians and the company that they owned and operated shared revenue from the anesthesia services with these referring physicians and provided different types of subsidies for drugs, supplies, and other equipment for the referring physicians' outpatient surgery centers. And so, I think one of the big takeaways, obviously, it's a pretty eye-watering amount of money, $7.2 million. In addition, OIG, I think what's important about this case is that it highlights OIG's longstanding concerns with the provision of free or below market value goods and services to an existing or potential referral source. OIG looks at this and says that, free or below market value goods and services might be used as a vehicle to disguise or confer conduct that would otherwise be unlawful, that would otherwise result in unlawful payment of referrals under the federal healthcare program, and sort of implicate the kickback statute. The second one here is from July 2022. This came through OIG's self-disclosure protocol. A gastroenterology practice group in Michigan received remuneration from a sports medicine practice and surgery center in the form of ownership fees. In the form of ownership interest in the surgery center and reimbursement for related legal fees. The hit here is $261,000. To the provider's credit, they made the disclosure through OIG's self-disclosure protocol, which undoubtedly saved them time, money, energy, effort by self-reporting. So I'll always put a plug in for the value of using the self-disclosure protocol where it's appropriate. So again, with this one, just as a reminder, the remuneration can take many different forms, right? Here it was an ownership interest and reimbursement of legal fees. And then there's one other one that I want to touch on briefly that I didn't put in a slide, but I think it's interesting too, nonetheless. Again, just because of the dollar amounts at issue. But this one was a recent False Claims Act settlement out of California from April of this year, involving a doctor, his son, some medical practices, an ambulatory surgery center, and a billing company. So you had a cast of thousands there, and basically the government will just sort of lump them all in and say the settling parties. But essentially, these parties agreed to pay almost $24 million to resolve allegations that they violated the False Claims Act by submitting or causing the submission of false claims to both Medicare and Medicaid. And the government's contention was that from 2015 to 2021, these parties manipulated the place of service code on claims for wound care and skin grafts to fraudulently maximize reimbursement under Medicare and Medicaid. And what they were doing here was they were performing these various procedures in an office setting, but billing them as though they had been performed in an ambulatory surgery center. In addition, the government alleged that the doctor had failed to properly dispose of unused portions of single-use skin graft materials and instead used them on later procedures with other patients, which resulted in several instances of double billing. And so, in addition to the $23 million or almost $24 million settlement, the provider and his practice group was excluded from participating in federal healthcare programs for 15 years. And his son, who owned and operated the billing company, was excluded for a period of 3 years. So again, exclusion is a very real tool in OIG's toolbox, and it's something that they will deploy as the circumstances warrant. And so, kind of with that in mind, here's just a couple last concluding thoughts for you. Healthcare changes fast. And again, the hope would be that the new frequently asked questions process is going to give providers an opportunity to get guidance from OIG in a more rapid way. Of course, as we discussed, subject to different limitations. It's also important to note that at this time, still, the formal advisory opinion is the only way, the only process that's available out there to providers for them to get sort of binding, conclusive guidance from the OIG. So as slow as it may be, or as cumbersome as it may be, that's still the only game in town for formal opinions. As we talked about here in the last couple of minutes, right? Assessing whether or not an ASC or a physician affiliated with an ASC satisfies the kickback harbor. It's a pretty complex analysis with significant risk, as we've seen from these most recent settlements, right? And it's certainly one that, given the complexities, should be reviewed by experienced healthcare counsel and Just to go back to my friend Warden Norton, here, the goal obviously in any circumstances is to keep providers, on the right side of the government, whether it's the OIG or the DOJ, and to help keep them out of trouble, by helping them make sure that their compliance programs and safeguards are robust. If for whatever reason, they get inquiries from the government, then that's a different analysis and a different step, but it's certainly one that, again, experienced healthcare counsel can help you with. So just be mindful of the pitfalls of to providers that are under the kickback statute, and understand that we don't want to create Warden Nortons. We want everybody to stay on the good side of the government. So with that said, I thank you for joining me this morning, and I hope that you enjoy the rest of the presentations, and I look forward to our upcoming Q&A session together. Thanks again so much for listening today.